Chandra, Academic Dean, Acropolis, Mr. Dev Jyoti Burman, Managing Partner at ACE Legal, Ms. Anu Moga, Partner, Anant Law, Ms. Dr. Ayaz Ahmed, Associate Professor at Karnavati University, and Mr. Rakshanj Ankit, Advocate, Patna High Court, and the author of the current Moot proposition. I, Anushka Siemens, the convener of the Moot Court Committee of ICFAI Law School, ICFAI University, Dehradun, welcome you all to the final rounds of the second virtual National Moot Court competition. The past 2 days of the event have been memorable and truly must to witness for each one of us. This is to state that the Moot Court Committee has successfully conducted the preliminary rounds, the quarter-final rounds, and the semi-final rounds on the 11th and 12th of November, respectively. The aim behind this competition was to provide all the participants and to all the law students an opportunity to enhance their research and drafting skills. The combined efforts of the committee members and the valuable contribution of the faculty members, the sponsors, and the continued efforts of the judges and the participants have enabled us to arrive here today for the final rounds. The two best teams that came all along fighting from the preliminary rounds are here today competing against each other in the final rounds. We began this round for the sincere hope and healthy debate and experience. The teams that have qualified for the rounds are TC05 as the petitioner and TC24 as the respondents. From here, I would like to invite our Dean, ma'am, Assistant Dean, ma'am, Monica Kharola, ICFAI Law School, to extend our gratitude to the judges for their esteemed presence and welcome them. Over to you, ma'am.
Ma'am, you are muted, ma'am. Please unmute yourself.
Sorry. Okay. I hope you can hear me now.
Yes, ma'am, you are audible.
Okay. Thank you very much. Firstly, I would like to welcome the guests, our judges for the day. And Anushka has given the details of the events that we have had so far. We are very happy that all the top law schools in India have, put in their best, competed with each other, and it has been a learning process for all of them. Whether they have come to the semi-finals or whichever round they have participated in, I'm sure that they will go as winners, all of them. Today, I would like, on behalf of ICFAI Law School, to welcome the judges who are one of the essential part of any mooting competition. I thank Mr. Divya Jyoti Burman, the managing partner of ACE Legal, Mr. Akshansh Ankit, advocate Patna High Court, who has been, very helpful in formulating the Moot proposition. I also thank Professor Dr. Gitanjali Chandra, Academic Dean, Acropolis Institutions. I also thank Ms. Anu Monga, Partner, Anant Law, and also thank Associate Professor Dr. Ayaz Ahmed. All of y'all, thank you. I know that Sunday is one day when y'all get an opportunity to relax, and even that you have sacrificed for the sake of learning. I'm extremely thankful, and we are there. Please do come to our campus whenever you can, and we'll send you invitations in order to see that students have more learning opportunities from people like you. So thank you once again, and I wish the contesting teams all the best. May the best team win, but it is a win-win for both the teams. So thank you, and over to you, Anushka.
Thank you so much, ma'am. From here on, I would like to hand over the platform to the court masters and the moderators to begin with the proceedings of the court. Wishing all the very best to both the teams. Thank you so much.
Before starting with the competition, we will have roll call of all the participants present in the courtroom. You are requested to respond yes when I call out name. TC05 Speaker 1.
Over here.
TC05 Speaker 2.
Yes.
TC05 Researcher.
Yes.
TC24 Speaker 1.
Yes, sir.
TC24 Speaker 2.
Yes, sir.
TC24 Researcher.
Yes, sir.
If it may please your ladyship and your lordship, I would like to address the honorable bench collectively as your lordships.
Yes, you may.
Sure, please continue.
Much obliged. A very good morning to our honorable judges and all our participants. It's my pleasure to welcome you all to the final rounds of the second virtual National Moot Court competition organized by the ICFAI Law School, ICFAI University, Dehradun. With the permission of your lordships, I would like to enlighten participants of both the teams with few rules and regulations of the court.
So permitted.
Much obliged. Participants must ensure they have wired headphones connected to their laptops during the oral pleadings and must keep their videos on. Participants are not allowed to leave the courtroom until permitted. Participants must ensure that they have a strong and stable internet connection. Relaxation of only 2 minutes will be provided in case of any connectivity issue. It is upon the discretion of the bench to decide whether they want to deduct any marks or not. Placard will be shown when the last 5, 2, and 30 seconds are left. If the speakers fail to see the placard, only the participants will be responsible for the same and no extra time will be provided to them on that account. Extra time will only be granted by the judges at their own discretion. Participants are not allowed to speak, make any gestures, sign, or behave indecently during the pleadings of other participants and maintain the decorum of the court once they enter the courtroom. No communication is allowed between the participants, and you are requested not to reveal your identity or your college's identity. The breach of this rule may lead to disqualification. Now, I would like to proceed to the time bifurcation. Each team is allotted 30 minutes of speaking time. Now, I would like to ask the petitioner TC05 to tell how they would like to bifurcate the timings between their speakers.
Much obliged, your court officer. Speaker number 1 shall be taking 23 minutes. Speaker number 2 shall be taking 5 minutes, and 2 minutes is for rebuttal.
Thank you.
Much
Now,
obliged.
I would like to ask the respondent team TC24 to tell their time bifurcation.
So speaker 1 will be taking 16 minutes and speaker 2 will be taking 13 minutes and the last 1 minute is for the sir rebuttals.
Thank you. Now, if the teams are ready and your lordship permits, the court can start with the proceedings.
Yes, you can proceed.
Much obliged. The court is now in session.
The counsel on behalf of the petitioner would like to address the bench collectively as your lordships. The counsel would like to start with the statement of decision.
Yes, please proceed.
The counsel on behalf of the petitioner most humbly and respectfully submits to the jurisdiction of the case before the Honorable Supreme Court under Article 131 of the Constitution of Indiana. If the lordships are satisfied with the statement of jurisdiction, the counsel would like to start with the statement of facts.
Yes, argue on the jurisdiction. Why should we hear your petition?
Much obliged, your lordship. Article 131 states that there must be a dispute and there must be a question of law or of fact on which the existence or extent of legal right depends. Now, so far as the parties are concerned over here, Article 131C, it says between 2 or more states. So that is fulfilled over here. And now when one more aspect of this particular article is that there must be a dispute between the states and there must be a question of legal right over here. Now, the state, there is a violation of legal right of the state over here. And that's why we have approached the Supreme Court under this article. And we also have precedent regarding this particular thing. And first of all, we must understand the statement of facts. What happened is that they have amended the code, and they had provided the code with some subsections which are discriminatory, and they have empowered a Russian-based project AI platform that have totally biased reports regarding the accused. And on basing upon these particular reports, the police are relying on these reports, and also the trial courts are convicting people based on these reports. And hence, and when a report came out and media started to channel these things, and the violation, there was a, and it was completely seen from this particular matter that they have been convicting only the migrants of state of Rajasthan, majorly. And there was a report which said that out of 1200 plus cases, 900 plus were the migrant workers from Rajasthan. Hence, it shows that how the reports are biased and how the courts and the police officers are relying just on the reports and are convicting left and right. Also, there was a dead man who was a migrant worker. He died. And after 2 days, this particular platform is convicting him of some offense which he never committed. Now his family is going through grief, and the police is knocking at the door, and of some accused offense which he has never committed. Also, there was a dispute.
Clarification here. Can you equate individual right with legal right of a state?
Much obliged, Your Lordship. For that, I have to directly go to the issue number 1, where we have explained this particular thing. Now, legal right. The term legal right should be understood in a generic sense, as Justice Bhagwati says in the state of Karnataka versus the Union of India. She says that, quoting her, the word right is used under Article 131 in a generic sense and not according to its strict meaning. We all know that the scope of Article 131 is different from that of Article 32 and Article 26. But we must understand that when a state's legal right is being violated, that will indeed give the power to the state to invoke Article 131. Here, she is saying, again, the word right is used in a generic sense if the state claims to be entitled to legislate exclusively on a particular matter on the ground that it falls within the 7th schedule of the Constitution, and the Union of India questions the right of the state. The dispute would be one relating not to any right of the state in a strict sense of the term, but to the liberty of the state to legislate on such matters. And these particular things will come directly within the terms of Article 131. Also, we have a precedent that will answer the questions that the Lordship has raised. And that is, a same scenario happened. State of Jharkhand versus state of Bihar. Now, state of Jharkhand has filed the petition under Article 131. The parties were also only the states. And same things were questioned over there because some provisions of the Bihar Recognition Act were violating the Article 14. And they came up with Article 131. And there was a preliminary objection raised by state of Jharkhand, state of Bihar, the opposition. They said this should be this petition is not maintainable. As we have seen in the state of Madhya Pradesh, the Supreme Court has said that these things are individual rights, and Article 131 is not for this particular thing. But the council over there from state of Jharkhand provided the precedent of state of West Bengal versus Union of India, where the petition was accepted, and the same things, the subject matter was same. And it was 2-bench judge in the case of in that particular case, that state of Jharkhand was the state of Bihar, and they said that we regret for our inability to understand, and then they have said that we referred this particular case to a higher bench. So they have maintained this particular petition, and they have accepted. And this particular petition, this particular precedent, we have mentioned in our issue number 1. Page number 17, footnote number 8, we have mentioned this particular thing, and there it is said very clearly that the justices are saying that we are unable to agree with the proposition that this court cannot examine the constitutionality of a statute in exercise of its exclusive original jurisdiction under 131. Now they are saying that the court has the ability to examine the constitutionality of a statute when invoked under Article 131 of the Constitution. Hence, this is the reason why we have approached the Supreme Court under Article 131 regarding the subject matter that we have.
Mr. Counsel, I have a question for you. Looks like that you, am I audible?
Yes, Your Lordship.
Yeah. So it looks like that you have challenged these particular provisions of the amendment primarily on the ground that the courts are more prone to convict the accused person on the basis of that particular report. But is that so? Is the right of defense of the accused person is taken away by the amendment? And if that is not, then why the accused person will get any prejudice because of this amendment? Because right of defense is always there. And secondly, you may be aware of that the presumption of guilt is constitutionally held valid in many other provisions. I do not know whether you are aware of not, like POCSO Act or provision under section 138, presumption of guilt is there. So the right of rebuttal, or rather the right of defense, the presumption of innocence of guilt is shifted upon the prosecution, and the accused will have to prove his innocence, contrary to the general provisions of criminal law. So here also the similar provision is mentioned, that the presumption of guilt would be shifted on the accused person. So the accused person will have the right to defend himself by way of whatever evidence that he has in his favor. So how this particular provision you are trying to hold constitutionally invalid, if the similar provisions of law is already held constitutionally valid in other provisions of law which I just referred to, like POCSO Act or provision under section 138. How would you counter that particular aspect?
Much obliged, Your Lordship, as you have said. But we must understand the scenario over here is a bit different, because they have provided a provision. Provided that when the question is whether a person has committed any offense and it is shown that he is guilty of committing the offense as per report of Pehchan AI platform, it may be presumed, unless the contrary is shown, that such person had committed such offense under the doctrine of reason beyond doubt. That is well established doctrine in the criminal procedure. And in the many case laws, the judges have said that let 100 people go free, but not one innocent should be convicted. Now, based upon this doctrine, if we see over here, if a defense does not have the evidence to prove, but the court will still assume that whatever the reports have been produced by Pehchan, they are going to base their judgment on this particular
report. No, kindly see the provision. It is presumption of guilt unless and until contrary is proved. So contrary, the right to prove the contrary is already there in favor of the accused person. The accused person can always prove his innocence, like the other provisions of law that I have just referred to. So only because the presumption of guilt is there, that perhaps is not the proposition of law under which the court can hold this to be constitutionally invalid. Probably you are harping on the issue presumption of guilt. The presumption of guilt is available in many other provisions of law under the current scenario, at least in the Union of India, Government of India, the central legislations.
Much obliged, Your Lordship, but we must also see the section 173. They have also amended this particular section where they have said the report so obtained as referred to subsection 9 shall necessarily used to identify the offender and shall form a part of police report. Now, what the word used over here is shall. Now, it is a compulsory for the police that they will take the report of Pehchan AI platform. And this Pehchan AI platform has been producing biased report. We must go to the facts also. When these people were migrating from that state to this state, Mr. Subra, who was not in power, he produced some harsh statement, and he said that these Pakistanis come over here and they work and they take the jobs over here. But under right to work, I can go in any other state and I can work over there. The Constitution provides me this particular right. And hence we can understand from this particular fact also that Mr. Subra, who came in contact with the President Vala Nitesh, and they have together had this idea about creating this AI platform. And this AI platform has been empowered by these subsections, which is producing even fallacy reports. One of the report is also there that a man died And after 2 days, that platform is convicting this dead man of some offense he never committed. So by these particular instances, we can come to the conclusion that this particular platform has been empowered by this subsection, and it is been producing the such a biasness report. And hence, and also
Mr. Counsel, 1 minute. The question which my brother has asked is this simple question, straightforward question, that just because there is a presumption of guilt created by the amended law, does that on its own make the law to be invalid, unconstitutional? So you are asking, you are responding with reference to the different kind of inconsistencies which might have happened, which might have taken place. But on the question of law, just because there is presumption of guilt created by these amendments become unconstitutional. That is your contention, isn't it?
Yes,
so?
Your Lordship. Yes,
So
Your
what is
Lordship.
the basis for your contention when so many other laws in the country, Union of India, you have so many other laws which carry this presumption of guilt?
So those, much obliged, Your Lordship, those laws are substantive, but the code is procedural. And we must understand in the Menka Gandhi case, there was
presumption, everywhere presumption of guilt is created through procedural law only. Which substantive law creates presumption? Most of the provisions, they relate to procedure, Evidence Act or CRPC. Mostly Evidence Act.
Much obliged, Your Lordship, but we must also consider the particular doctrine that we have well established in our criminal procedure, that is the reason beyond doubt. But here in the procedure, when they are adding this particular subsection, that presumption is there. So whenever the word presumption comes, there is a doubt. Because when we presume something, there may be some part of it which is not correct. It may be right, it may be wrong, but the criminal, that the doctrine that we have, the reason beyond doubt, it does not work on presumption. It works that the reasons must be such that there is no amount of any doubt. For example, if a man steals and I have the video cassette of it, that he is stealing, and the court of law will see it, will interpret it, and then it becomes reason beyond doubt that this man is the thief. But here it is the presumption. And when we put such provision in the procedural law, it will hamper Article 21. As in the Menka Gandhi case, it is said that not every, it is not that the state can put any procedure, or it is not that the court provides any procedure, but the procedure needs to be right, fair, and just. And here we can see that the procedure is only based upon presumption, and hence it is in contradiction with the doctrine that is well established, which is reason beyond doubt. And this is our contention over right here.
Don't you think this is only about police report, but the court will sit over that police report, examine that police report before giving any conclusion whether the person has actually committed the crime or not? So don't you have any faith in the court that they will examine the police report in right perspective?
Much obliged, Your Lordship, but from the fact sheet itself, we can clearly see we respect the courts. The courts try their very hard to interpret it, and they have produced some landmark judgment. But in the fact sheet, we have seen it clearly that the trial courts in Madhya Pradesh started convicting accused person after considering the report of Pehchan AI platform. So from the fact sheet itself, we can identify that how just with the excuse of speedy trial and fast trial, they have neglected their particular duties that they had on the interpretation and judging capabilities. The police have been relying on this particular report. The investigating efforts have been reduced. That clearly shows that how this will degrade the efforts that they must provide while investigating and also while giving a judgment. So, and this is the root cause, because this particular provision, and it is said in the fact sheet, this resulted in speedy investigation and trial of criminal case in Madhya Pradesh, which was and as they have also mentioned over here, why it was all happening speedily and fast? Because of the provision imposed, section 293(5) of Code of Criminal Procedure Act 1973, which was the amended act. It is in page number 20, point number, under the subsection it is provided, this particular fact. So we can clearly see how, because of such provisions which got amended, the trial courts have been not properly interpreting the reports, and also have been basing their judgments just on a report of a platform which is not even from this country, it is from a different country. So this is our contention regarding this, but the question that you have asked, your lordship. That if the
Yes, please
lordship
carry out
We'll
with
move for the
the
second issue, then it's subject to consent of my
Much-
brother judges.
much obliged, your lordship. The council would like to start with the issue number 2.
Please
Whether
proceed.
the Code of Criminal Procedure Mudra Pradesh Amendment Act 2018 is ultra vires of the Constitution of Indiana. Now, the fundamental rights are very, very important. They are necessary consequence of the declaration in the preamble to the Constitution that the people of India have solemnly resolved to constitute India into a sovereign, democratic public and to secure all its citizens justice, social, economy, and political. Part 3 of the Constitution protects substantive as well as procedural rights. Now, it is well established in the cases like Menka Gandhi, Indira Sawhney, Ajay Hasia. Justice Bhagwati quoting her, it must be remembered that the fundamental rights are constitutional guarantees given to the people of India and are not merely paper hopes or fleeting promises. And so long as they find a place in Constitution, they should not be allowed to be emasculated in their application by a narrow and constricted judicial interpretation. Now, Article 14 has been violated over here. Article 14 bars discrimination and prohibits discrimination laws. Article 14 is now proving as a bulwark against any arbitrary or discriminatory state action. Article 14 of the Constitution provides equal, and Bhagwati, quoting her again in the Menka case, she says, when a statute vests unguided and unrestricted power in an authority to affect the rights of a person without laying down any policy or principle which is to guide the authority in exercise of his power, it would be affected by the vice of discrimination, since it would leave it open to the authority to discriminate between persons and things similarly situated. Clearly, from this statement, we can understand that when a statute gives power to some authority and there is no guidance for the exercise of that power, it is going to be discrimination at some point of time. And here, same thing has happened. These particular subsections were amended, which empowered a foreign platform, AI platform, which has been taking the data. And from this part, we can understand it is also violating the right to privacy, which is one of the aspects of Article 21. The expression life in Article 21 has been interpreted by the Supreme Court rather liberally and broadly. And as we have, and if we understand properly, that right to privacy has been given as a very important aspect of Article 21. And it is clearly being violated over here. Because these
will first explain us clearly how the amendments violate Article 14, because amendments apply equally to everyone in the state of Mudra.
Much obliged, your lordship. But we must understand that this particular subsection is empowering such a AI platform that is producing biased reports. So if we add the chain of events, we can directly get to the point that it is violating Article 14.
So
just because the
bias is created by the platform,
we can understand it from the facts itself. If we go to the facts, we can see that when these people for the first time they were migrating from that state to this state, Mr. Subra produced some harsh statements, and he called them these Pakistanis. They come over here, they take our job, they take the schemes, and to balance that particular thing, this this Pehchan project came into effect. But when this particular leader, when he won and he came in contact with the president and he was reviewing these particular things, they together formed this idea, and from this idea came these subsections. And from these subsections, that platform got the power, and from that power, it began to produce began to produce these biased reports, and hence Article 14 has been violated over here. Because we all know
statements of politicians. Can you show that bias or prejudice discrimination is inbuilt in this Pehchan project? The statements of politicians, they are not evidence that discrimination or bias is created. Either you will have to show in the law or in the application of the law that results are discriminatory.
Yes, your lordship. Verily, as you have said, that and I agree on this particular thing, that this is violating the law. Because as we know that a report was produced. In that report, 900 people were convicted, and they were from the Pakistanistan. And now this report, if they were true to themselves, they would have said that this report is baseless, but they never said. Actually, they defended this report. If we go to the fact sheets, then the president of that particular platform is saying that no technology is perfect. And when he is saying these particular words, diplomatic, it is a diplomatic statement. When he is saying these particular words, when a fallacy came out from this particular project, he is defending himself, but actually he is defending the report that came out with the title regional discrimination, Pehchan platform regional discrimination. And he is also saying, and from that particular thing, Article 15 subsection, Article 15 is also being violated because these people are being convicted because of the place of their birth, which is in Pakistan. And hence we can come to this conclusion that this particular platform that has been given the power by the subsection is against Article 14 and also Article 21, since right to privacy is being violated over here.
Mr. Counsel, don't you think that you are challenging this particular provision only because there is one report whereby it appears that there was some lacuna or fallacy in the particular Pehchan scheme? Because the data, as far as the data available with us, that is the only perhaps infraction of this total system whereby it appears that it was not properly applied. And secondly, you may be aware of that if there is a proper ocular or eyewitness evidence is there, then it can always weigh upon the way against the electronic evidence. It's not that electronic evidence alone can convict a person. If there is a proper evidence and you can rebut that the presumption of guilt against you, then why are you so afraid of this particular scheme of this Pehchan, that in each and every cases they would be convicted? If the parties are indeed innocent and they can produce the ocular evidence to rebut their the presumption of guilt, then there is nothing to get worried about. So why there is a right of privacy? And you are also maybe aware of that in other case, the right of privacy has been upheld. That is why in other in the Aadhaar card, the private details of the every citizens of this particular country is being shared in a particular portal. So why do you think because of Pehchan the privacy is being misused or is breached?
Much obliged, your lordship. The case of Aadhaar, from reading over this particular thing, anyone can come to this conclusion that yes, Pehchan is just like the Aadhaar one, but we must understand this Pehchan is not of this country, not established by the government. This is a foreign country. It comes from a foreign country. Whereas Aadhaar, this particular scheme was established by the government. And we also, we don't have just one report. We have other report also, where a dead man is being accused of some offense which he never committed. There is a vast difference. Now, if we go into the deepness of this particular Pehchan, we can identify it and we can match it on par with Pegasus, the spyware that leaked so much of data. And that particular Pegasus was created for the protection of that particular country only from the criminal attacks and terror attacks. But later, it began leaking data of every other country. So this Pehchan project is much more identical to the Pegasus.
Pegasus has not been authenticated by the government of the country. That yes, it is indeed the government authorized software that was misused, and that is there is no confirmed stand that was done with the consent of the state. But in this case, the scheme has been initiated and is being performed with the consent of the state by the way of this amendment. So there is little difference between Pegasus and this Pehchan scheme.
But it gives us the right to come before the court when this is violating the legal right of the state. And as I have proved before also that this petition is maintainable. Hence, we can come and challenge these particular amendments that haven't taken place. We are not talking about Israel, who actually, your lordship, we talk about the country of India over here. And in India, we can challenge the laws. We have this particular perks. And we must also understand that this Pegasus was created by the NSO Group Technology, is an Israeli technology firm. And Pehchan is also a technology firm based in Russia. And both of them, from the face itself, they say that, yes, we are going to provide something which will benefit the people, also the country. But later on, Pegasus turned violent. It leaked data. Even it leaked the data of our Chief Justice of our country. These Pegasus, by this subsection, we have allowed this Pehchan to crawl into our judicial system. They can monitor the activities of the police. They can monitor the activities of the judicial system, also the judiciary, and hence they can leak the data. And we know that how the international politics works. Two countries can become bitter enemies within few seconds. And we all know that Russia have been in good terms with the enemies of India. And these things can turn violent at any time. And it will not be just violating the privacy of people. It will also be it will also violate the privacy of the judicial system, the police, the courts, and the legal data also will be violated. Hence, this comes under.
Russia is a very old friend of India. Now you are saying that Russia is a friend of enemies of India. Russia is a very Russia is a very old, reliable friend and ally of our India. And now, how can you say that they are enemies suddenly?
From much obliged, Your Lordship. From the history itself, we have we know this particular fact that best friends have turned into best enemies. So just because of this particular thing that Russia and India are on good terms doesn't mean this will lie for eternity. And now in this particular technological era, anything can happen at any time.
Council,
So
when you are comparing with the PCS and the other things like the company which is actually state has permitted, so the other member has want to state you that thing that this is not a case which you are actually comparing with. And as per the rules, as time is out, you have to ask the Lordship for the time.
Apologies, Your Lordship. The Council would like to seek few more minutes to sum up the particular issue.
You have to ask to other members, are they allowed for the time and all?
Your Lordship, it's upon the discretion of the judges.
Perhaps only one issue is left, third issue. So we can hurriedly proceed to the third issue.
Much obliged, Your Lordship. It is also in violation of the international conventions to which India is a part of. It clearly says in that particular international declaration, Article 12 of UDHR, no one shall be subjected to arbitrary interference with the privacy, family, home, or correspondence, not to attack upon his honor and reputation. Now, the honor and reputation of a particular man has been violated over here because he died, and after 2 days, he is being accused of some offense he never committed. Hence, the reputation and the honor of that particular man is violated over here. And hence, it is also in violation to the international declarations. And this is how I'll sum up my issue 1 and issue 2. The council would like to seek permission from the lordships to, and the issue number 3 will be dealt by my co-counsel. Much obliged, Your Lordships, entirely.
Yes, you're allowed. You can counsel.
With the due permission of Your Lordship, the council on behalf of petitioner would like to proceed with issue number 3.
Yes, you're allowed.
Much obliged. It is respectfully submitted. The issue was whether Pehchan project can be used to adopt to grant social welfare schemes to citizens or not. It is humbly submitted before this Honorable Supreme Court that Pehchan project cannot be used to grant social welfare schemes to citizens. As my co-counsel has stated that there is several ways in which Article 14 is violating, I would like to enlighten in a wider sense. If you see the nature and scope of Article 14, it says that the equality clause contained in Article 14 requires that all persons subjected to any legislation should be treated alike under circumstances and conditions. It is mentioned all persons. As the report of Ameshwar Foundation, Pehchan have convicted 987 migrant workers out of 1234, which is a regional discrimination. And there is a motive. There is a motive behind this regional discrimination happened because AI is developed by, as we all know, that AI is developed by human brains. And therefore, human can make artificial brains according to their wishes. So that is that means that AI can be programmed with biasness. Your Lordship, the Council believes that AI of Pehchan app is completely biased. The biasness of Pehchan caused the regional discrimination by convicting 987 migrant workers out of 1234, which is nearly 80%. We know that if we see in the facts that the migrants of Pehchan's Prachinstan had not been well liked by Mr. Subra from the initial time when he was the opposing party leader. He said that these Prachinstans come here and become a burden on our finances. And most of these outsiders don't work at all, but always first in the queue to receive benefits which are given by our tax money and our cost. Your Lordship, the Council believes that to avoid the payment of allowances and benefits to migrant workers under some sections of Interstate Migrant Workers Act of 1979, under section 13, 14, 15, and 16 of Interstate Migrant Workers Act 1977, Council seeks apology. This is the motive. This is the motive which creates which is creating the biased AI with the help of in-vivo organization by Mr. Subra. And this biased AI-based biased Pehchan give preference to migrant workers while convicting. The Pehchan AI gives migrant workers preference to convict. Suppose there is four prime suspect of any crime, and 3 of them are original residents of Madhya Pradesh, and one of them is from Pakinstan migrant worker. So now the biased AI platform will do what? Will do convict that Pakinstan migrant workers and not the others, not the original residents. So this application is completely biased, and this application of Pehchan software is also violative Article 21, which is right to life. Suppose any accused, after being noted on police record, Pehchan app will record his name and his data. And if the accused found innocent after the fair trial, the record of Pehchan's database stays as his name and his crime. So by this, his right to life and right to livelihood is being violated, because as an innocent, his name stays in Pehchan's database as an offender in Pehchan database. Suppose and I would also like to enlighten some facts, some judgments of case Puttaswamy case. The case Puttaswamy case first recognized that right to privacy is a part of Article 21, which is right to life. Justice Chalmers said that liberty is the freedom of an individual to do what he pleases, and the exercise of that freedom would be meaningless in the absence of privacy. And also Justice Sarad Arvind Babde, who was the 47th Chief Justice of India, said the right to privacy is inextricably bound up with all exercises of human liberty, both as the specifically enumerated across Part 3 as is guaranteed in the residue under Article 21. So this, the Pehchan project is also violated of Article 14, 15 and 21, because right to privacy is also violated because this is a Russian app, and the Russia country can, there is no guarantee that they will not sell it. Our citizens of our country's data can be easily sold on international market. So as we can see, the Pehchan is violated of Article 14, 15 and 21, and also violated right to privacy as a foreign app. Hence, it is not qualified to grant as a social welfare scheme to citizens. The council seeks permission of your lordship to proceed with the prayer part if you are well versed with issue 3.
Can you explain, you see, in we have held already that Aadhaar does not violate right to privacy. Aadhaar does such a detailed profiling of the citizens, but still it does not violate fundamental right to privacy. Then how does this Pehchan violate fundamental right to privacy? In which way does it violate fundamental right to privacy?
Your lordship, Aadhaar is developed by UIDAI, which is the Aadhaar Authority of India, and it has the AI platform. UIDAI is an Indian platform, but here in this case, Pehchan is a Russian platform, and there is no contract, nothing, no guarantee that they cannot sell this data to for international market. So your lordship, this is the
main ground is something, a technology which has been developed in India, and when it is developed in a foreign country. Zoom in which we are interacting is a technology developed outside of India. English language is not an Indian outside Indian, the system. Common law system is not an Indian system. It is adversarial system is not an Indian system. It is based on, it originated and was developed by foreigners. So just because something is developed by foreigners, are we going to reject all of it, even if it is suitable, useful, and it helps the citizen of Indiana?
There are actually, I'm sorry, Council, there are actually several other applications that are used in day-to-day life, which have become integral part of conversation for the citizens of Indiana. If your argument is extended, all of them will cause privacy issues, just because they are foreign applications.
Laptops, mobiles, everything.
Your lordship, no, the apps which are used in current day life is authorized by the government of India. But in this case, this Pehchan app is not authorized by the government of Indiana. It is a state is directly told Russian in-vivo organization to make this, and they made it in a biased way, because it cannot be happen that 80% of convicted are of Pakistan. So this is why we are saying
that people who have migrated from Pakistan, they are being migrants and not having any roots in the state of Mudra. They are committing more crimes. If they are committing more crimes, there will be more conviction from their class of people. That
Yes.
does not. That on
Yes, so Lordship, that is true. But look, the people are not founding when the council seeks apology. Council would seek some few minutes. Council would seek.
Sure. To consult your co-counsel?
No, not consult. To continue my argument.
Just quickly conclude, please.
Yes. The question you asked that in the workers came to Mudra Pradesh to work, to have good employment opportunity, which is not available in his Pakistan. So a person who is getting good salary, good allowances in Mudra Pradesh, so why he would indulge in criminal activities? Because if they stay at Pakistan, they may do some criminal activities. But in Mudra Pradesh, they are well paid, so there is no need of indulge in criminal activities. So if your council well versed with issue 3, the council council seeks permission of your lordship to proceed with the prayer part.
Yes.
Much obliged, your lordship. In the light of the issues raised, argument advanced, and authority cited, the petitioner most humbly and respectfully pray and request the Honorable Court, number 1, to declare that present petition is maintainable before this court. Number 2, to declare that the Code of Criminal Procedure, Mudra Pradesh Amendment Act 2018, is ultra vires of the Constitution. And number 3, to declare that the Pehchan project cannot be adopted to grant a social welfare schemes to citizens, and or grant any order, direction, relief that this honorable court may deem fit in the eyes of justice, equity, and good conscience, all of which is respectfully submitted, and for such act of kindness the petitioner shall be duty bound as ever pray. The petitioner rests.
Court Master, can please continue with the proceedings?
Yes, now the respondent TC24 speaker 1 may proceed.
Thank you so much, Court Master. So before I begin, I would just like to confirm if I'm both clearly audible and visible.
Yes, speaker 1, you're both.
Thank you so much. Warm greetings to the Honorable Bench and the Learned Counsel for the petitioners here. May it please this Honorable Supreme Court of Indiana, this is the Advocate General appearing on behalf of the state of Madhya Pradesh in the case of state of Rajasthan versus state of Madhya Pradesh. If I may be of no inconvenience to your ladyship, may I please address the bench jointly as your lordships?
It's fine. Yes, please.
Much obliged, your ladyship. The present and
counsel, why are you not addressing or seeking permission to address us as your ladyship? Why only lordship?
Your lordship, the council would like to change if your lordships accept, if your lordships are fine with the entire bench collectively being called as your ladyships.
And what is the problem with your honor?
Whichever is convenient to your lordship, the council would address the bench as that.
Gender neutral term, your honor.
Much obliged, your honor. If the bench is well versed with the facts of the case, may I please move on to the issues of the present case?
Yes, bench is aware of the fact. You can proceed. Even the first issue looks to be more or less settled, that this bench or this particular court has indeed power to adjudicate the constitutionality of a particular provision of law. Now, before you proceed to defend this particular law, I put a question at the very beginning that you may be aware of that the mens rea, the mental state of mind, is the primary factor behind committing any crime. And you are also know in criminal jurisprudence, without proof of mens rea, many of the crimes may not be proved, or may not be, the accused person may not be held guilty, even if the crime is found to be have been committed. So now, if you first satisfy this bench, how come a particular technological platform can establish this fact, this mens rea, mental state of mind, a particular state of mind of a person, that he indeed committed the crime with all the necessary ingredients of mens rea? You first satisfy this point.
Much obliged, your honor. So the present Pehchan project, the artificial intelligence, it is collecting all the details of a person. Like if you're looking into the proposition, it is clearly telling that the Pehchan project is collecting different informations like the financial background, the caste category, the medical history. Above all, it is also collecting the criminal history of a particular person, along with the browsing history as well as the call networking site. So by collecting all this information, it is the AI platform is actually processing who would be probably committing the particular offense. And by processing all this data only, the AI platform is coming into a conclusion that this person, the presumption of the mental state of the accused is being determined by the AI platform, Your Honor.
So when you are using the word probability, you know, the in criminal jurisprudence, the degree of proof is proof beyond reasonable doubt. Had it been a civil proceeding, it would be an preponderance of probability. But since it is a crime in criminal jurisprudence, the degree of proof will have to be proof beyond reasonable doubt. So if there is a scope for ifs and bounds, and you also know that the general law that is followed in Indiana or Union of India, that hundreds of innocent criminals may be go unpunished, but not a innocent person is to be punished. Then how this artificial intelligence platform, which is perhaps ill-equipped to form an opinion whether there was a menstruation or not, can be used for the purpose of having a presumption that this man is guilty. Mere collation of data, don't you think that mere collation of data is not enough to prove the state of mind?
Your Honor, if we look deeply into the amended section 293 of the CRPC, which is clearly telling that the report of the Pehchan AI platform may be used as an evidence in an inquiry. So the use of Pehchan, it is the report which is given by the Pehchan need not be mandatorily used in the inquiry. So the accused, say if any person has been called as an accused by the particular platform, the accused is being given a chance for a free and fair trial. He may come to the court and he may defend his innocence. So the report of the Pehchan project only may be used in evidence, but nowhere it is mentioned that it should be used as an evidence, Your Honor.
Counsel, from the facts of the case, can you point out any particular circumstance where the report was not used as evidence? Considering you're pressing upon the fact that it is the section mentions may, if you can point out in the facts a particular situation where the report was not used as evidence.
Firstly, Your Ladyship, in most of the case, the proposition is actually silent about the particular fact, but with whatever the Advocate General is able to interpret from the proposition, it is that because of the accuracy of the Pehchan project, the report of the Pehchan project is being used as an evidence. So it is the accuracy factor which is making the Pehchan used in almost all the cases that have been used up till now in the country of India, in the state of Madhya Pradesh. Right. So since it's accurate, the report of the Pehchan is still being used, Your Honor.
So, counsel, considering that the section mentions may, if the may is used as a shall, then the interpretation of statutes will not read the may as a may. Therefore, you would have to supply facts to say that there are indeed certain reports, in certain cases, reports are not being used as evidence, and that's how the provisions may is used as a may. Please go ahead.
Much obliged, Your Honor. So, if the bench, does the bench want the counsel to continue with the arguments for the first issue about the non-maintainability of the original suit, which is filed by the state of Rajasthan?
Yes, subject to satisfaction of other members, it is constitutionally we can adjudicate the issue. So you can satisfy the point that has been just raised by another member of this bench, shall and may.
Your Honor, but the council would the respondent, the state of Madhya Pradesh, is actually praying for the dismissal of the original suit. So because state of Rajasthan should have not come before this Supreme Court under Article 131 through this original suit, because they should have approached like with whatever rights that the petitioners have contended here. Everything is with regards to the fundamental right. So when there is a question of violation of fundamental rights, then the petitioner should have approached this Honorable Supreme Court under Article 32, but they have in this present case approached under Article 131.
There are precedents that the petitioner has submitted before us. There are precedents that where under Article 131 also the constitutional or bias of any provision of law was challenged before this bench. So there are precedents. How do you distinguish those precedents?
Your Honor, the one precedence which the counsel for the petitioners relied upon, the state of Jharkhand versus state of Bihar. Your Honor, in the state of Jharkhand versus state of Bihar, the petitioners challenged a central law, that is the Bihar Reorganization Act. So it was the central law which the petitioners challenged in that particular case. But in the present case, the petitioners are challenging the validity and virus of a legislation which was duly passed by another state, that is the state of Madhya Pradesh. So there are huge differences between challenging the central law and challenging a legislation that is passed by another state. And in the present case, when there is no legal right of the state that was affected, or when there is no existence of a legal right of the state of Rajasthan, then there is then the petitioners do not come under the purview of challenging the validity of a state legislation under Article 131.
But that decision did not hold either that the state legislation cannot be challenged under Article 31. That was the subject matter of the dispute, and since it was incidentally a central legislation, then the Supreme Court decided on the issue. But the ratio was not framed, or ratio was not held that the state legislation cannot be adjudicated by this bench under Article 131.
Indeed, yes, Your Honor. So along with it, also another important prerequisite for 131 is the existence of legal right. So as I mentioned earlier, there was no such kind of legal right of the state which is being affected here. So whatever rights that the petitioners contended that it is being violated, it is all of a private individual's fundamental right. So the state as a whole, it is coming before this honorable Supreme Court, and they are challenging it under 131. So when there is no infringement, or when there is not even an existence of a legal right, then there is no whole point for the petitioners to come before this court under 131, Your Honor.
In that state of Jharkhand versus state of Bihar case also, pensionary benefits of individuals were involved. The question of pensionary benefits of individuals were involved. Still, this court accepted the maintainability of the case. So how do you say that this case is different from that case?
As I mentioned, indeed, much obliged, Your Honor. So as I mentioned earlier, again, the Bihar Reorganization Act was one of the acts which was passed by the Lok Sabha. It is a central legislation, Your Honor. But in the present case, the state of Rajasthan, out of nowhere, they are coming and they are challenging a state legislation which is passed by the state of Madhya Pradesh. So the central legislation can be questioned. So the dispute when it is between central and the state legislation, that can be questioned. But in the present case, they are questioning one of the state legislation which is passed by the state of Madhya Pradesh. So this cannot be brought under the purview of 131.
Clause A of 131 and clause C of 131. If under clause A, legislation of Government of India can be questioned before us, because there is a dispute between Government of India and state. Similarly, legislation of a state can also be challenged if there is a dispute between two or more states under clause C. You just look at the original provision of the Constitution.
Indeed, yes, Your Honor. So a dispute when it is between two states, it can be entertained under a petition under 131. But that dispute should be on the existence of a legal right, which is not present in the present case, Your Honor. Because as I mentioned earlier, there was no such kind of a legal right which is being violated here. All the rights which the petitioner said is being infringed is all of a fundamental right nature. So they should have come before this Supreme Court under a writ jurisdiction and not under an original jurisdiction.
Fundamental right is not a legal right?
Your Honor, legal right, as mentioned by the petitioners, it is of a broader nature. So under legal rights comes the fundamental rights. But so, Your Honor,
whereas legality is concerned, fundamental right is also legal right. Is it
indeed,
explained?
yes. Indeed, yes, Your Honor. The council is completely agreeing to the fact that fundamental rights are also legal rights. But for the infringement of fundamental rights, when you have something, when you have a special jurisdiction exclusively for that, and when such kind of a writ jurisdiction can be invoked under 32, the petitioners, when they have an alternate remedy, they should have exhausted it before coming under 131.
Right.
And moreover, Your Honor, I would just like to add one more point with regards to the non-maintainability, that in the present case, like the caveat in the regard of the present case is that it is fully touching upon the political concerns, and when a petition it is touching only upon political concerns, it would be outrightly rejected by the Supreme Court. And this was also one of the principle that was held in the case of State of Bihar versus Union of India, that when a question is brought before the court, is purely a political question, not involving determination of any legal or constitutional right or obligation, the court would not entertain it, since the court is concerned only on the adjudication of the legal rights and liabilities. So in the present case, Your Honor, the Labour Party of Rajasthan has filed this suit in the fear of losing the majority in the state of Rajasthan. And if we look in reality, in the state of Madhya Pradesh, it was the same Labour Party in 2015 when they were in majority. They extended the Pehchan project to all the social and medical benefit schemes of the state. But right now, through this suit, they are challenging the same validity of the project which they had brought in the state. So this is all is clearly showing that it is fully of the suit is based on political concern, and also the suit has been filed on the basis of an NGO report, which cannot be the sole basis for the petitioners to file a case before this honorable court. So considering all these contentions, the respondent, the state of Madhya Pradesh, is humbly submitting that the petition should not be maintainable and should be dismissed. And with the due permission of the bench, can I please get an extension for 3 minutes to argue for the third issue?
Yes, so please proceed quickly.
Much obliged, much obliged, Your Honor. So the third issue for the present case is whether the Pehchan project can be used or adopted to grant social welfare schemes to the citizens. Your Honor, it is humbly submitted that the Pehchan project, which is an AI-based platform developed by InfoView, can be adopted and used for the efficacious implementation of social welfare schemes to the citizens. So firstly, Your Honor, Indiana is a welfare state, and under Article 38, it also imposes a duty on the state to secure a social order for the promotion of welfare of people. So identification of beneficiaries is very crucial to the fulfillment of social welfare programs. In the present matter at hand, the AI platform installed is an inherent part of the legislative efforts of the state of Madhya Pradesh to ensure that the benefits are channelized to those whom they are meant for. And with regards to the violation of privacy that the counsel for the petitioners argued upon, it cannot be claimed that the use of Pehchan is infringing the fundamental right to privacy. So touching again upon the case of Justice K.S. Puttasamy retired versus Union of India, the case is recognizing the right to privacy as a fundamental right. But the same is not an absolute right, and the restrictions can be imposed in. And to check upon the restrictions, we have the fourfold test. So I would like to elaborate on the fourfold test.
Counsel, you will use the Pehchan to grant benefit to people who are already dead, as is clear from the reports?
Your Lordship, that the use of Pehchan in that case is with regards to the criminal justice system, and what the council is now arguing is about giving the social welfare schemes to the
Pehchan, no? In order to identify the beneficiaries of social schemes, so you will distribute it to dead people.
Indeed not, Your Honor. The Pehchan project, it is an AI platform, and if you look into the statement of the developer, who said that no device, no technology can be perfect, and the Pehchan is 99.99% perfect, and errors could happen at the
That is so, Ms.
0.00.
Counsel. If that is so, then why don't you limit this particular platform to only for augmentation of the social welfare schemes only? Why are you using this for the purpose of, identification of any person who may have committed the guilt? Don't you think that is a little difference between a social welfare scheme which is being used by a platform, but you, at the same point of time, you are using the platform for the purpose of, the shifting the onus of proofs on the accused person that he may have committed the crime. So perhaps there is a two different issue, whether a platform can be used as a social welfare scheme or whether a particular electronic platform can be used for the purpose of, for identification of guilt. So don't you think those two are different issues which are perhaps you are mixing together?
Indeed, yes. Indeed, not, Your Honor. The council seeks an extension of time from the honorable bench.
Yes, very shortly.
Much obliged, Your Honor. So, indeed, not, Your Lordship. We are not mixing both the issues, and that's why I am particularly dealing with the Pehchan project extending only to the social welfare schemes, and my co-counsel will be elaborately dealing upon extending it to the criminal justice system, Your Honor. So, with regards to the question, Your Honor, do you want me to answer to the particular question?
Yeah, whosoever want to answer, but I just the bench wants to know how would you mix both the issues, which are prima facie are different issues.
Your Honor, we're not the respondents are not mixing both the issues, Your Honor. So I am dealing exclusively with the Pehchan project used for granting social welfare schemes, and as I said earlier, my co-counsel will be dealing about the Pehchan project in the criminal justice system.
All right, then we request your co-counsel to answer the question.
Much obliged, Your Honor. So my co-counsel has taken note of the question, and she'll be answering to the question in her course of argument. So may I please move on to the arguments for the third issue? Can I? The council seeks the permission of the bench to sum up the arguments for the third issue.
Yes.
Much obliged, Your Honor. So the fourfold test which is being satisfied in the present case, Your Honor. So the first test is the legitimate goal stage. So the Pehchan, like ordinary people in the state of Madhya Pradesh, especially when we look into the pensioners and the marginal sections of the community, they are not denied of their benefits till an adequate mechanism for authentication of providing them with the adequate social welfare schemes are put in place. So the main motive of the state of Madhya Pradesh in incorporating the Pehchan project into the social welfare schemes is that nobody is being excluded, and it is enough to furnish the information in the Pehchan, and wherever even in the places where the infrastructure is not functioning, even in those places, the beneficiaries will be identified by the Pehchan project and they will be given their entitlements. So this is what the government wants, and it is clearly satisfying the legitimate goal stage. The second test is that the suitability or the rational connection. So only if data is being obtained by the Pehchan project, it can ensure that the extent of benefit is given. So the state has a legitimate concern to check that the welfare benefits which it marks for those who are entitled reach them without any diversion. So the third test, Your Honor, it is the necessity stage. So no doubt that there are many modes by which a person can be identified. So however, certain categories of persons, so again, when we particularly look into the people who are living in abject poverty and the illiterate people, they will not be in a position to get other modes of social benefits. So the manner in which malpractices have been committed in the past or in the state leaves the government to hold that apart from the system of using an AI in social welfare schemes and the authentication of the real beneficiaries, there is no alternate measure with lesser degree of limitation which can achieve the same purpose. And the final test, Your Honor, it is the balancing stage. So the whole purpose of the Pehchan project is to accurately identify the beneficiaries of the state welfare schemes, and that it is achieved that by balancing two of the fundamental rights, that is with privacy on one hand, the other one being the right to live with dignity, and which includes the right to food, right to shelter, and all the other social welfare benefits So the Pehchan project is indeed a necessary and proportionate measure to ensure that the targeted delivery of social benefits and services and to prevent any leakage of services. So with in the light of your first arguments, it is most humbly and respectfully submitted before this honorable bench that Pehchan project should be adopted and used by the state of Madhya Pradesh in granting social welfare benefit schemes to the citizens. So if the bench is satisfied with my arguments for the third issue, may I please call upon my co-counsel to continue if there are no further questions.
Ms. Advocate General, can we cut short this matter? You withdraw the criminal amendments and will allow the social welfare scheme?
Your Honor, initially before the Pehchan was introduced in the criminal justice system, so the Pehchan was still was used in in granting of social and medical benefits, and later by seeing the promptness and the efficiency of the Pehchan project, only we included it in the criminal justice system. And right now the Pehchan project is being accurate enough, like it is giving 99.99% results, and it is being accurate enough in finding out the accused, the criminals, and also it is helping the state in speedy trial. So the respondents seek the bench to allow the use of Pehchan project in both the criminal justice system as well as in social welfare schemes. If my answer satisfying, Your Honor?
Proceed with the next speaker.
Much obliged, Your Honor.
Kindly address, as also pointed out by my learned member of this bench, kindly address how you reconcile both the issues, criminal administration of criminal justice as well as social welfare scheme.
Indeed, yes, Your Honor.
You explain that thing, whether you or your co-speaker kindly satisfy this bench how this issue can be addressed. Reconciliation, reconciling both the issues which are prima facie separate.
Your Lordship, we had been with the council's knowledge, we had actually bifurcated both the parts like into two. So I dealt exclusively with the use of Pehchan project in the social welfare schemes, and my co-counsel in her further argument, she is dealing with exclusively about the Pehchan project in the criminal justice system.
So please request your co-counsel to answer these questions.
Much indeed, yes, Your Honor. It was an honor arguing before this bench. Thank you so much.
Greetings to the Honorable Bench. May it please the Honorable Court. Your Honor, is the counsel clearly visible and audible?
Yes.
Much obliged, Your Honor. This is the counsel appearing behalf of respondents in the case between state of Rajasthan and the state of Madhya Pradesh. Your Honor, as my co-counsel has already dealt with the issues of maintainability and the issue of Pehchan being implemented in social welfare scheme, the counsel would further proceed with the constitutionality of the criminal amendment. Before getting into the actual arguments, the counsel would like to answer to the two questions put forth by my Honorable Ladyship and the Lordship. First, answering to the question of the Ladyship. Ladyship posed a question as to whether the use of word may is existing in the actual real circumstances in the state of Madhya Pradesh. Your Ladyship answering to that question. Your Ladyship, with regard to facts in the matter, first I'd like to answer to the question of the amendment itself. The amendment paves way for whether or not AI report to be admissible or not admissible by using the word may. The amendment states that the AI report may be used as an evidence, thereby giving a discretion to the Honorable Magistrate in the trial cases. Also, Your Ladyship, even though, let us suppose it is to be considered as an evidence, still the matter of presumption rests in the hands of the magistrate. It is up to the magistrate to presume it to be against the guilt or for the guilt, Your Ladyship. Your Ladyship, Section 4 of the Indian Evidence Act states that this may presume is a natural, permissive, and rebuttable presumption. And in order to make such presumption, the magistrate shall ask for more documents or more evidences to come to that presumption. Thereby, it is the discretion of the court whether or not to accept it as an evidence, and secondly, whether or not to come to a presumption based on such evidence. And Your Ladyship, with regard to facts in the question, as far as facts are concerned, the facts are very silent about whether it is used or not used. Your Ladyship, thereby the Additional Advocate General will not be able to elucidate on that matter. However, the Additional Advocate General would like to point out to the fact that there are various other sections in the Indian Evidence Act, likewise from section 86 to 90A, section 113A, section 114 and 114A, which gives such mere presumption. And the court in several matters have denied to come to such conclusion, presumption, and in several matters have made some presumption. Thereby, it is very arbitrary and cannot come to a conclusion whether it is used in every case or not used in every case. Thus, the Advocate General would abstain from getting into such matter, Your Ladyship. Also, Your Ladyship, can the Council move to the second question? Much obliged, Your Honor. The second question posed by Your Lordship is that why is the Council for the Respondent trying to use Pehchan for social welfare scheme as well as for criminal justice system, and why we are reconciling both the issues and mixing it, Your Lordship. Lordship, the Council for the Respondents wants to clarify that this Pehchan initially was used for social welfare scheme, and the data that were collected were exclusively for social welfare scheme. And now, after the amendment, it is used for criminal justice system also. But Your Lordship, then we have to see the nature of data that is being collected for social welfare scheme and for criminal justice is different. Lordship, if you could see page 2, para 3 of the Moot proposition, initially for social welfare scheme, it was only the medical background, the caste detail, financial background, and criminal history that were collected. And post the amendment, when it is introduced for the criminal justice system, the records of mobile phones and social networking is collected. So this Pehchan itself acts in two different natural ways. One is for social welfare scheme and another is for criminal amendment. As the Honorable Bench has accepted to use this Pehchan for social welfare scheme, considering its reliability, now the Council would only stick.
Proposing nothing. We have not accepted.
Your Lordship? Sorry, Your Lordship.
Accepted yet.
Indeed, Your Lordship. The Council would now like to only stick about the criminal amendment. Your Lordship, with regard to any amendment in place and to constitutionally challenge any amendment, there must be only two grounds. Whether it violates the fundamental rights, contravening the rights enshrined under Part 3 of the Constitution, or the second one, it is about the legislative competency or whether the doctrine of repugnancy comes into play. Your Lordship, in our present case, the legislature has passed this amendment by procedure established by law by exercising its inherent power enshrined in Article 245, Clause 1 of the Constitution. And there is no question of repugnancy because CRPC is under the concurrent list, Schedule 7, List 3, Entry 2. And this amendment is not contradictory to any central amendment. Thereby, the question of legislative competency or doctrine of repugnancy is now out
Ms.
of
Counsel, kindly enlighten this bench whether you have taken the assent of President or the Governor of the state while notifying these particular amendments in the official gazette. Whose assent was taken, of Governors or the President of India?
Your Lordship, of the Governor was taken, Your Lordship, since considering it to be a state amendment. However, there is no contention that was raised by the Union of Indiana with regard to this amendment, Your Lordship.
Yes, perhaps the issue has been raised between the two parties, but if we find later on there is indeed some repugnancy, then don't you think on this ground alone this act can be held repugnant because you have not taken the assent of the President of India because this is a central legislation and you are making an state amendments?
Indeed, Your Lordship, as far as now it is in concern, there is no such repugnancy. However, the Advocate General would now advise the government of Madhya Pradesh to seek the President's approval, Your Lordship. And still
but how can this amendment can be again? Then you have to repeal this act and you have to make a fresh act for the purpose of taking the assent.
Your Lordship,
this lacuna cannot be corrected anymore only because of by taking the assent of the President.
Your Lordship,
perhaps you know that.
Indeed, Your Lordship, we have taken the assent from the Governor, and since considered to be a state amendment and the matter being listed under concurrent list, the state is given inherent powers by the Constitution to make any such amendments.
And another question, as it appears from your submission, that you are also utilizing the social strata or economic strata of the particular citizen for the purpose of applying this AI platform to find out whether he has committed the guilt or not. Are you using that platform also, economic standard or social backwardness of that particular person? Are you using that platform, that data rather?
Your Lordship, the data is just collected, but the report that comes out is not solely on the financial background or the economic background of such person. Rather, it is inclusive of all other data like the records of mobile phone, the social networking things, and the criminal history is taken into consideration, especially when it comes to the matter of criminal justice system, Your Lordship.
And how would you satisfy that point in addition to your co-speaker? How would you satisfy this bench about the applicability of mens rea in an artificial intelligence platform?
Indeed, Your Lordship. Your Lordship, with regard to the applicability of mens rea, this could be answered in a two-limb manner. Firstly, this AI report is not a conclusive evidence that is given before this honorable court. It is up to the court to apply its mind by basis of this AI to consider if there is mens rea or not. The AI report is not substituting the role of a magistrate. Rather, it is only assisting the investigative officer and assisting the magistrate in trial cases, Your Lordship. Your Lordship, still, the role of the magistrate lies in considering whether the mens rea is present or absent in any offense. Also, Your Lordship, with regard to AI report does not say that he is a guilty person. Rather, the AI report states that he is a possible accused. He is a possible, Your Lordship.
The petitioners are claiming that the learned magistrates are blindly following these reports. So what do you have to say on that?
Your Lordship, this is something that is overreach of the facts, and the facts does not say so that the magistrate are blindly following this report. Your Lordship, the only contention that they could corroborate from the fact is that out of 1,234 criminals, 987 from the state of Pakistan. This is the only contention that they could corroborate to this fact, to this contention. But Your Lordship, if you could refer to page 1, para 2 of the Moot proposition, it states that Pakistan is called as a crime capital of Indiana, and the criminal offenses and convictions in Pakistan is that high. So it is natural that the people of Pakistan, the migrant laborers, to involved in such offences. However, Your Lordship, the Advocate General is not in prejudice that all people in Pakistan are offenders or habitual offenders, but rather in the light of the facts that is given in the Moot proposition, it appears to be so, and the conviction is also appearing to be so, Your Lordship. However, Your Lordship, the accused...
If you refer to, because you are referring to the facts present in the problem, if you look at page 4 and second last paragraph, it clearly tells us that police across Madhya Pradesh started solely relying on Pehchan AI platform to investigate criminal cases and identify and prosecute offenders. Even trial courts in Madhya Pradesh started convicting accused person after considering the report of Pehchan AI platform in view of the presumption imposed by the proviso. This resulted in a speedy investigation and trial of criminal cases. So how are you saying that magistrates and police, they may do it, may not do it, they have the discretion, they have taken the easy way out? The fault is not with the magistrate, but with the law. You have made a law whereby magistrates are casually disposing of the cases by taking into account this report, which is prima facie arbitrary and discriminatory.
Your Lordship, the counsel for the respondents humbly beg to differ on this aspect. The counsel would like to point out to the fact that the investigative officers are not magistrate and they're only taking assistance from Pehchan report. Also, the fact given in proposition exclusively states that the trial court in Uttar Pradesh, after started convicting the accused person after considering the report of Pehchan, not solely relying on the report of Pehchan. So the word consideration, which means that they are only using the may presume clause and not applying the shall presume in the present case, Your Lordship. Consideration is, Your Lordship, is there any
you have made a law which raises a presumption of guilt, turning the criminal justice system on its head on the basis of a platform which is discriminatory and arbitrary. It is a very serious matter.
Adding to it, See, the thing is, you have to consider only 2 points, the mobile number and the social media presence of these people. See, while not considering, when we are considering the criminal fact, the fingerprinting, DNA printing, and eye scanning, and all these things, if considered, like I will take the example of Emirates ID, because so UAE ID, when they are taking the eye scanning, everything is there. If these things are missing, how can be it's the sole determining factor of the crime? That's the bench wants to say. And the whole conclusively, when you are considering all these facts, that these are the factors which has to be considered: presumption, corroboration. But the facts, when you come into the facts, you have to be restricted with the facts of the case when you are presenting that thing.
Indeed, Your Lordship. The council understands the concern of the bench. Your Lordship, if you could refer to page 3 of the Moot proposition, the proposition says that for the better accuracy, including the access to records of mobile phones, this data that is collected is inclusive of nature, not exhaustive in nature, Your Lordship. So the details as to the iris scans, the DNA analysis, the macro analysis is also taken into consideration during the time of investigation. And this could be corroborated to the fact that this amendment states that it is mandatory for the police officer investigating to furnish and upload all relevant information. And during the time of, Your Lordship, considering the time is out, the council seeks extension of further minutes to elaborate on the same. Thank you, Your Honor.
Please sum up your argument on the question raised by the landed members.
Indeed, Your Lordship. Your Lordship, the police officers are mandated to furnish all the relevant information. And while filing an FIR or while the case moves on to the investigation stage, every information right from the thumbprint to every other detail like DNA and macro analysis is taken into consideration. Thereby, it is not only the mobile phone records or the social networking records that are only collected, and based on such records, only the AI report is given. Rather, it is inclusive in nature, Your Lordship. And that is what the council wants to contend. Also, Your Lordship, now, because it is according to the procedure established by law, the second question is whether it is due process of law. And due process of law must be seen in light with the golden triangle, which is Article 19, 14, and 21. Your Lordship, in the present case, with regard to Article 14 is in consideration. The 14 is with regard to the right to equality and whether any act or conduct of the state is arbitrary in nature. In E.P. Royappa versus State of Tamil Nadu, the court stated that when, Your Lordship, you could refer this in the memorial submitted by the petitioners for the respondents, the court stated that when we consider the arbitrary test, the amendment or the statute itself must be arbitrary in nature, or it must pave way for any classification. In our present case, Your Lordship, the amendment is not arbitrary in nature. It does not pave way for any classification. This could be corroborated with a fact given in page 2, paragraph 3.
If the amendment is not arbitrary, how is your AI platform is identifying dead people as criminals 2 days before the occurrence of crime? Tell us, satisfy us, how is it not arbitrary?
Indeed, Your Lordship. Your Lordship, the Honorable Bench definitely knows the constitutionality of any act is seen with respect to the language of the act. But this, what happened with regard to dead person being incriminated, is a flaw in the executive's part. An execution of the law can itself find the law to be arbitrary.
Right. The AI platform, if we refer to the facts, AI platform identified a person who was dead 2 days before the occurrence of crime as the criminal.
Indeed, Your Lordship. Your Lordship, that is where the presumption of may applies. Now, the magistrate has to apply their mind whether or not to admit the evidence. Also, Your Lordship, this AI platform is 99.99% reliable.
Right. So in that case, can you then strike off the proviso from the amendment? Because the proviso is what is raising presumption of guilt. If it is only about making use of AI platform, probably we can allow. But because it is raising the presumption of guilt, that makes it very difficult for any of us to sustain the constitutionality.
Indeed, Your Lordship, the counsel for the respondents would accept to the fact that this proviso should be struck down when it is raising the presumption of shall presume, whether it is only may presume. And in the case of Tukaram versus State of Maharashtra, 1979 SC 1979 AR 185, this honorable court stated that the presumption of may presume is aiding this court to deliver speedy trial. Your Lordship, in the Husainara cartoon versus State of Bihar case, this honorable court stated that speedy trial is enshrined under Article 21. And in our present case, by the way of this proviso and by the way of this AI report, speedy trial is implemented, Your Lordship. In fact, this has been appreciated by the jurists and experts across the globe. Also, Your Lordship,
if you concede that this proviso is unconstitutional and it should be deleted, then what is the justification for rest of the amendments? You know, there are already provisions under Evidence Act where electronic evidence can be taken into account. So then if proviso is severed from the amendment, then there is no need for the amendment. The entire amendment can be declared struck unconstitutional, or you can repeal the entire amendment.
Your Lordship, with regard to electronic evidence coming into place, electronic evidence is given by the parties. For the prosecution, they are giving the electronic evidence, and the affidavit is given by the parties. But when AI report is in consideration, it is given by the investigative officers upon submitting all mandatory details to AI Pehchan. So it falls apart from the conventional electronic evidence that is given during the time of trial, since this AI report is based on the information collected by the IO officer during the investigation. Also, Your Lordship, it is pertinent to note that this AI report being in place is not something that happens for the very first time in the world. In fact, the 87th Law Commission report made in duty to upon recommendation upon the states to implement innovative methods. And such innovative methods like AI in criminal justice system is followed in New Jersey, in New York, and in state of China, wherein, Your Lordship, the state of China have went to a level that they are in fact using AI for granting of bail and parole. But in our present case, we are not going to such extreme measures, but being reasonable under Article 21 by giving it only as an corroborative evidence, that too under the discretion of the magistrate, and such corroborative evidence raising to presumption only under the discretion of the magistrate, Your Lordship. Thereby, it is constitutional, Your Lordship.
Counsel, what is more, disturbing, whether granting parole and probation on the basis of AI and raising presumption of guilt on the basis of AI? What is more offensive? Probation parole is a relief to the person who is already convicted. And here you are trying to convict an innocent person on the basis of AI, comparing with China.
Your Lordship, the council seeks permission of 1 minute to answer this question. Your Lordship, the council only wanted to substantiate the fact that in the countries like China and US, the AI is substituting magistrate. They are also raising a presumption. But in our present case, in state of Madhya Pradesh, the AI is not substituting the magistrate, aiding the magistrate and assisting the magistrate and giving all discretion to the magistrate whether or not to consider the report, whether or not to apply his mind upon the report and raise a presumption. Thereby, it could not be found to be unconstitutional in nature, Your Lordship.
If
Also,
that
Your
is
Lordship,
so, Miss Counsel, then why don't you separate this platform and use it only exclusively for the purpose of criminal justice system and not for social welfare measures as well? Why are you not separating both these two issues? Because still to the bench, it looks like the social welfare measures cannot be, the measures cannot be fulfilled by a platform which is also used for the purpose of identification of the guilty person.
Indeed, Your Lordship. Your Lordship, Aadhaar is in effect. UIDA collects details from every person, and it is used for both social welfare and also to find the accused. Especially in CBI investigating economic offences, the iris scan, the thumb impression are taken only from Aadhaar database. Similarly, in our present case, the Pehchan is collecting the information. However, so for social welfare scheme, it is a different modus operandi, and for criminal investigation, it is a different modus operandi. Thereby, the state of Madhya Pradesh is not confusing social welfare and criminal justice system. Rather, Pehchan is collecting this detail and working in a different modus operandi for different legitimate goals, Your Lordship. Your Lordship, if there are any questions.
Can you conclude now your argument?
Indeed, Your Lordship. Your Lordship, the Council would like to conclude by stating that this falls a due process of law, and the right to privacy, right under Article 14 and 19 are not absolute in nature. Also, this AI report does not go against Article 20 Clause 3, the rule against self-incrimination, as stated in the case of Selvi versus State of Karnataka and Ritesh Sinha judgment. Also, Your Lordship, due process is followed by following the procedure established under Section 69A of the IT Act, Rule 15 and 16 of the Intermediary Guideline Rules 2021, Section 5 Clause 2 of the Indian Telegraph Act and Rule 419A of the Indian Telegraph Rules. Thereby, we are confining ourselves to the guidelines passed by this Honorable Court in PUCL judgment by acting in consonance with the procedure established by law and the due process under these statutes, Your Lordship. Also, Your Lordship, the important contention is only two contention. One, this AI is favoring speedy trial, which is an enshrined right under Article 21, which was given in Hussain and Cartoon case. And the very important last limb of the argument is that the presumption of constitutionality. Your Lordship, in the case of Union of India versus Elphinstone Spinning and Weaving Company Limited, the court, Honorable Court stated that there are two contentions when we consider the constitutionality of an act. One, the burden of proof is upon the petitioners. They have to cull out the exact words that is unconstitutional in nature. In our present case, the petitioners have failed to do so. And such contention must be put forth beyond reasonable doubt, Your Lordship. Also, the pro-constitutional interpretation of any act state that there must be a strict application of interpretation with respect to the language of the act. Here, the language of the amendment is may presume, thereby falling under the constitutionality. Also, with regard to amendment, why it is being implemented and why it could not be the other way is policy matter, which is an inherent right of the legislative and not judiciary. Thereby, the council would like to close the argument. Your Lordship, would you like to hear a prayer from the council for the respondents?
It's all right. I think time is over, and thank you very much.
Much obliged, Your Lordship. It was an honor to plead before this honorable court. Thank you, Your Lordship, and Your Ladyships.
If Your Lordship permits, then the team TC05, the petitioners, can move ahead with the rebuttals.
Yes.
The
Much
council,
obliged, Your Lordship.
the council, with the permission of the Lordship, would like to start the rebuttal.
Yes.
Now, the respected council have said that 245, Article 245 allows state legislation to amend the laws. Very well, but that does not justifies of a law which is violating the article. It allows the state legislature to amend the laws, but that does not mean that they will amend the laws and make it such a way that it will violate the articles. Rather, their arguments have been shattered when they have said that AI is not conclusive report. And when the report is not conclusive, but judgments are given on the basis of that report, it is clearly the arguments have been shattered over here. And they have also said that when the respected Lordship have pointed out that a dead man was accused of the offense which have never committed, they have said that it is the fault of the executive authorities, not the legislative. But we must understand, yes, the powers have been divided, legislative, judiciary, and executive, but they are interconnected. If the legislation in itself is at fault, then we can't expect the execution of those particular laws to be perfect. There will be fault, because in the origin only, there is a great fault over there. And then the respected council have said that the police have taken assistance from the Pehchan AI platform. There is a difference between assistance and relying. The fact says differently. The fact is saying, perfectly it is saying that they have solely relied, and not only relied, solely relied. The police is bringing up the report by solely relying on the AI platform, and the courts are recognizing it. Now they have said that there is a word may. It is on the discretion of the court. But it is clearly said that whenever it is provided by the act that the court may presume a fact, it may either regard fact as provided unless and until it is disproved by some other proof. But when the police is solely relying on the report of Pehchan, from where will the other proof come? Obviously, the defense will they will plead, but unless a different proofs arrive in front of the court have to, because of that provision, have to rely on the reports of Pehchan, which we have already contended that they are very biased in nature. And here the petitioner would like to end the rebuttal over here. Much obliged, Your Lordship.
Your Lordship, the council seeks permission to present the rebuttals.
Yes.
Your Lordship, my learned friend for the petitioners have put forth 4 questions. First, with regard to, though there is an inherent right under Article 241 Clause 1, and that cannot be violating fundamental rights. Your Lordship, fundamental rights are not absolute in nature, and this is held in case Puttaswamy case. The respondents have, however, dealt with the fact that how this AI Pehchan is reasonable and falls rightly and squarely under the reasonable restrictions. The second question was regard to how a dead person being incriminated and why the executive will be liable, and thereby this act should be unconstitutional. Your Lordship, with regard to the constitutionality and unconstitutionality act, it must go with respect to the language of the act. However, Your Lordship, the state of Madhya Pradesh has taken necessary actions against the serious blunder which is committed by the police officer, and the executor has been punished for the same. Your Lordship, when execution is the flaw, the act cannot be incriminated for the same. Your Lordship, in fact, the Dr. B.R. Ambedkar himself said that the Constitution is right, but the execution may go wrong in the upcoming future generations. Thereby, that doesn't mean that execution of Constitution is wrong. Then Constitution itself is wrong. The same principle will be applied here, Your Lordship. The amendment is right. It is constitutional, and there is slight flaws in the execution, and such flaws will be corrected by the way of the administrative actions, Your Lordship. And with regard to the third question, that was with respect to may being used and the police officer solely relying only on the Pehchan report. Lordship, if you could see the amendment, subsection 9 of 173, it states that it is mandatory for the police officer investigating the case to upload all relevant information to AI Pehchan. So even before this report from AI Pehchan comes from the AI Pehchan platform, the police officer must make every investigation, and he must upload all the investigation details along with other details into AI report to come to such conclusion, Your Lordship. Thereby, he is only taking the assistance from AI report. And the fourth contention was stating that when AI report is not conclusive, why to raise some presumption? The counsel for respondents were stating that this AI report is not a conclusive proof under section 4. Rather, it is only an evidence that may be admitted. The report is conclusive, but will not be a conclusive proof in the as an evidence before the trial. Lordship, with this, we'd like to close our rebuttal. Thank you, Lordship. It was an honor to plead before this honorable court. Thank you.
If your lordships doesn't have any more questions, then with the permission of your lordships, I would request the participants to leave this meeting and the honorable bench to kindly stay back.
Yes, sure. Please.
The participants are requested to kindly leave the meeting.
Mr. Courtmaster, would we have to come back for a feedback session or so?
If your lordships wants to give any feedback, then they can give the feedback now.
I would like to give one feedback. When you are using different concepts, constitutional concept like doctrine of repugnancy, then you must understand the circumstances in which it is applied and the up-to-date law. So, and you have to remain apprise yourself the latest law on the subject matter. So just simply because you are referring to different doctrines, principles, etc., without much clarity, that will be very, very counterproductive. We expect questions from the bench wherever you are participating, that the moment you drop a concept, principle, doctrine, there will be questions around it, and you have to be fully prepared. You have to take a decision whether what you are using, whether a doctrine or principle that you are going to use, whether it is actually going to be in your favor or it might prove counterproductive. If it can prove counterproductive, then you can avoid using it.
Yes, as rightly pointed out by my learned member, what I could find from the propositions, moot court proposition from both the parties, that the case decisions were cited galore, but whether those are properly applicable and what was the conclusion that the parties wants to draw from those decisions, that was not apparent. So that parties needs to be very clear on the issue whenever they are referring to any decision, what sort of ratio, what sort of principle that they are trying to draw from that particular.
One feedback from my side: when you are using that the magistrate has to apply their mind. The sentence is itself, it's not an like sentence which has to be used, because it can be used as a discretion of the court. So the language of whenever you are using for the judiciary certain connotation, certain sentences, it has to be in that a way that it will not be derogatory in that sense. That's you several times it's used by the team 24. So that's one of the feedback. Rest of the teams are very good. They because the argument, the case on artificial intelligence, but the example and the example which was given by team 5 also, that's related to that's enemy country and the presumption for the personal opinion should not be, it should be quoted by certain things. It should not be considered as a fact, like they will be immediately become enemy, and all these things are actually not suitable for the student who are like the law student. That word should not be used in, especially when it is a competition of moot courts. That's only a general feedback. That's nothing related to marking and something. It's just an opinion of mine. Might be we will consider or not consider. It's up to you.
I have one comment to make, and I think all my brother and sister judges have made already approached the issues that I had in mind. There's only one last one. I think Team 5 was referring to Justice, Honorable Justice P.N. Bhagwati's judgments and kept using the pronoun she. It's, please, whenever you, first of all, you should always address judges as Honorable Mr. Justice and use the right pronoun if you are trying to use a pronoun for a judge. It's going to actually do quite a bit of harm at court. And again, this is not going to affect the marking per se, but please make sure that you're not addressing judges as pronouns.
Yes, that's actually Justice Bhagwati, when you are saying that's like considering, that shows that like you don't know about the judgment, who has delivered the judgment, that you don't know the judges. That reflects in that way. So avoid using pronouns.
Absolutely.
Thank you, Your Lordships, for giving the participants your valuable feedback. Now I would request all the participants to kindly leave the meeting and the honorable bench to stay back.
Thank you, Your Lordship.
Much obliged, Your Lordship.
Thank you so much. Thank you so much, ma'am.
Now I would like to ask Ms. Anushka Shimendra to kindly take over.
A very good afternoon to all the judges. Now, as the session is over, I would thank all the judges for the valuable time from taking out time from their busy schedules and honoring to adjudicate our final rounds of the moot court competition. I would like to request our faculty convener, Dr. Sunil Kumar sir, to kindly address the gathering.
Thank you, Anushka. Good afternoon, one and all present here. I would like to express heartfelt thanks to all our respected judges of this final rounds for accepting our invitation and judging these final rounds of moot court competitions. By name, I thank Dr. Ahmad Sahab, Mr. Divyajyoti Barman Sahab, Mr. Akshansh Ankit, who is also author of this problem, Professor Dr. Geetanjali Chandra, and Miss Anu Moga. And because, of course, at the very outset, as our Dean ma'am have aptly asserted, that is the holy day. And in spite of your busy schedule, you all have accepted and spared the time for us. We are really very thankful to all of you and hope that this our association would not be this is not the last event where we would be expecting your cooperation, but in future also this association would continue and definitely will flourish. And I would be expecting your presence next time, not virtually, but physically also at this in our campus. I just invite all of you to come to our campus, and because Dehradun is also a good place. It's a good tourist place also, so definitely you would enjoy not only the this campus but also this the surroundings here. So once again, thank you all of you. I will not take much time because already you would have spared so much time for us. So once again, thank you all of you. So I think now it's the time for score sheets to be filled. So please take your time. Thank you all of you.
Thank you. Thank you, Dr. Sunil Kumar. Thank you so much. Thank you to the Dean and the entire ICFAI University and the students here who are also spending their Sundays with us. And thank you so much to Mayank, who kept his patience yesterday trying to chase me and update me. Thank you. Thank you, everyone. And I'll try this to make this not the only opportunity where we are able to associate with ICFAI. Thank you so much.
Yes, I may also express my note of thanks with the word that it is indeed a great pleasure and good experience to learn as well from the students as well as the other learned members of the bench. A lot of new things we have also come to know. And perhaps we are also fulfilling one of our undesired dreams. That had we been a member of the bench, how would have performed being the member of the judges bench. So thank you all for giving us this opportunity and hope to see you all in the near future. Thank you.
So just I want to thank you, ICFAI, Dr. Sunil, Akshans for the problem, because that's an interesting problem. And that's like the moot other than moot proposition. Thank you for the bench. Indeed, it's an honor, and truly like what Devjyoti sir has said, that's like it's the dream which we have not lived, but like living in that way, that the judging these sessions. Thank you, Anu. Thank you, Ayaz sir, and thank you the other members, and thank you the team for coordinating in such a way that like we are not felt that like we have not have the link and all that. Without glitches you have actually performed. And I'm from Acropolis group of institutions, so definitely looking forward all the judges to one of the moot court whenever we are organizing for our institution. Thank you, all of you. Thank you.
Thank you to all the judges. As the judges have delivered their vote of thanks, I feel that this entire student body is really privileged that you honored our gracious national event with your presence and took out time from your valuable schedules. Thank you so much. And I, as the convener on behalf of the entire student body at ICFAI, thank you all for judging the national competition. Thank you. Moving forward, I would request all the judges to kindly fill the marking sheet. And as soon as the marking sheet is filled, we'll confirm the responses. Along with it, soon after the session is over, a mail will be sent to all the judges containing the Google form of your seeking your postal addresses for the transfer of mementos. So please fill that. And now I would like to hand over the platform to the court master. Thank you, judges.
Thank you.
Congratulations, entire ICFAI team for organizing this wonderful competition. Congratulations, all of you, and thank you all the colleagues, brother judges here on the panel, and would look forward to have more such interaction in the future.
Thank you, Dr. Ayaz Saab.
If your lordships could kindly check their mails, we have sent the score sheets, and if you can kindly fill the same and we'll confirm it from the OC, then you can kindly leave the meeting.
All right. So,
should we leave the meeting right now or should we remain till the mark sheets are handed over?
No, your lordships, if you could find first, please fill the score sheet and then we'll confirm the same from the OC. Then you can please leave the meeting.
Okay.
Sure.